May it please the court, my name is Aaron Kling. I represent Ms. Lasser, the appellant. I'd like to reserve 5 minutes for rebuttal.
All right.
Ms. Lasser appealed the lower court's entry of summary judgment against her, as a lower court erred by improperly weighing the evidence and by failing to consider the expert affidavit filed on her behalf as to the cause of damages. The standard of review is de novo. Florida Rule of Civil Procedure 1.510 states that the court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact. In re-amendments to the Florida Rule of Civil Procedure 1.510, the Supreme Court stated that the correct test for the existence of a genuine issue of material fact is whether the evidence is such that a reasonable jury can return a verdict for the non-moving party. When performing this analysis, the court should resolve all reasonable doubts about the facts in favor of the non-movement and draw all justifiable inferences in our favor. The lower court in this case ruled as follows. Plaintiff does not meet her burdens of proof on the summary judgment evidence before the court to show direct physical loss to the property during the policy period to recover for any alleged exterior damage, or the exception to the rain exclusion that a covered peril first damaged the building, causing an opening in the roof or wall, and rain entered through this opening to recover for any of the interior damage. Plaintiff could not testify at deposition as to any specific damage to the exterior of her property. None of the other documents in the record suggest a physical loss to the exterior of the property such that a reasonable jury can return a verdict for plaintiff. Therefore, judgment is required against the plaintiff. Accordingly, I'd like to address the summary judgment evidence that would establish that there was exterior damage during the policy period and that the rain exclusion was met, or an exception to the rain exclusion was met. So, in June of 2019, a 4-point inspection was performed by a certified inspector, Jason Mason, who opined that the roof had more than 10 years of useful life and that the roof was in good condition, i.e. no damage. His deposition transcript is in the record at 947. Well, that's actually where that quote comes from. The policy period ran from June 27th, 2019 to June 27th, 2020. Ms. Lasser testified that on April 24th, 2020, it was extremely windy and it sounded like her roof was being hit with hail. That's in the record at 323. Ms. Lasser further testified that she reported the claim when she saw water dripping from the ceiling and the window frame on June 4th, 2020. This was during the policy period. Citizens presented no evidence to rebut that that's when this occurred. Ryan Pevler, a licensed 620 all lines adjuster, or insurance adjuster, performed an inspection of the property. This occurred just after the policy. On page 443 to 444 of the record, Mr. Pevler testified that he observed impact marks on the roof. Moreover, at page 447 to 448, Mr. Pevler notes a separation between the materials, which he opined were consistent with wind-shifting soft metal. The jury could infer that the damages Mr. Pevler observed occurred during the policy period based on Mrs. Lasser's testimony regarding the high winds and the sounds of the impacts. Additionally, defendant's field adjuster's photographs, which are also in the record, were taken on June 10th, 2020, which is also during the policy period. On page 291 of the record, 2 of those photographs include red circles around portions of the roof.
How good?
Yes, that's going to get to that one.
I'm trying to skip ahead to
Okay.
good stuff.
All right, Your Honor.
Can you explain to me why that affidavit was sufficient to create a genuine issue of fact?
Yes, Your Honor. Actually, he opined, Mr. Hopgood opined that, first describes the methodology he employed in reaching his professional opinions, including his personal analysis of the photographs collected by the parties, and an analysis of historical weather data available on the National Oceanic and Atmospheric Agency's website. He testified that this is the type of data that experts in his field rely upon in reaching their professional opinions, and that his testimony met the criteria of 90.74. His ultimate opinion was that the exterior damage was not caused by wear and tear, but rather by severe weather events in April of 2020.
And was that actually inconsistent with the AQA report that he was purportedly relying on?
Not necessarily, Your Honor, because it also talks about the exterior building envelope. And if we look at the report on of the record page 530, he stated the damaged and displaced sealant around the windows and doors, or door and window openings and between the wall sections observed at the subject property are consistent with the damage due to pressure differentials associated with high wind loading and deterioration of the sealant. The dislodged and displaced sealant created openings in the building envelope for moisture to enter the building.
So
And if we
but
skip-
is that different from damage to the roof? I mean, because they're two separate types of damage here, right? There's the roof damage, and then there's the interior damage caused by the water. So that might go to the cause of the interior damage of the water, but that's separate and apart from the roof, isn't it?
Yes, Your Honor, I would say there's 4 separate types of damage here. There's roof damage, this is a metal clad exterior building, there's separations in there allowing water to enter. And then there's soft metal damage, which doesn't require an opening. So if we look at the record at photograph photograph 52 at the record on page 571, we can actually see a separation in the building envelope with no sealant, which is consistent with water damage occurring below that window. We have photographs of water damage below that window.
But the bottom line is, there were 2 experts and 2 affidavits, right?
Only one expert on behalf of the plaintiff and no experts on behalf of the defendant.
Yeah, but there was an affidavit, right?
Yes, Your Honor, and in the third DCA has found in 3 separate cases.
Well, before we go there,
Okay,
let's just look at these 2 affidavits, and let's assume for the moment that they're both on the table.
Yes,
Okay?
sir.
One basically says the damage occurred because of a storm event, which is a covered event.
Yes,
The other one says it was just wear and tear, and that says no evidence of an opening or a storm event. Is that pretty much what they say?
that's pretty much what they said, yes.
Okay, so what's a trial judge supposed to do when a trial judge is confronted with 2 affidavits that say 2 separate things?
Send it to the jury.
Right, so this is a summary judgment, so this is really not an opportunity for a trial judge to weigh the credibility and all of those things, right?
Yes, Your Honor.
So what did the trial judge here say about these affidavits?
That it was a tie, Your Honor. And in that case, which we're drawing your inferences in the favor of the non-movement, the tie should go to the runner.
So, is that appropriate?
No, Your Honor, what you did was not appropriate, and we're looking to reverse. I kind of just want to highlight that not only do we have that, we have, with the roof issue, there was a repair that happened in the interim of those inspections. And if we look at the client's affidavit or client's responses to defendant's interrogatories, she states that those temporary repairs were made using a water sealant. And then if we look back at the photographs taken by the field adjuster, he has some red circles on the roof, which is consistent with that, but we don't know what his actual opinion was because those photographs, the comments on them were redacted. So it could have been that it got covered up before he had the opportunity to see it. But as we were saying, there's 3 different cases from the third DCA which found that this exact type of affidavit was sufficient to create a question of fact. That those cases are Fredericks versus Citizens, where the third ruled that after a thorough examination of the record, we found that the insured met a burden of showing the existence of a tribal issue as to the cause of her loss, which was based upon the testimony of a general contractor that microfissures in the roof were the cause of small wind gusts. Microfissures are something that you can't see with naked eye. I believe she wanted us to point, here's the hole. I think I could do that with the photograph on the record at page, or photograph 52 at the record page 571. But nonetheless, the Supreme Court was very clear when adopting the new Rule 1.510. And it's, I quote, "In adopting this amendment, we affirm the Red Rock principle that summary judgment is not a substitute for the trial of disputed issues. And that's what happened in this case, and therefore we ask to reverse. If there's no further questions, I'd reserve my remaining time for rebuttal.
Okay, well, your remaining time will only be 5 minutes, okay?
I understand, Your Honor.
Okay, thank you.
Good morning, Your Honors. May it please the court, Catherine Ender from Dinsmore and Scholl on behalf of Citizens Property Insurance Company.
Can I ask you a question about the issue that's been raised about your affidavit being hearsay, containing hearsay? You want to address that? Your opponent basically has raised that issue, says it shouldn't have come in because it's based on hearsay.
Certainly, Judge Morris. Appellant in this case is conflating the concepts of authenticity with the concept of hearsay. We have an affidavit from Ms. Carpenter who specifically testified that she was acting as corporate representative of Citizens. She had personal knowledge of the information that was contained within the file. It was contained within the course of business, and she admitted those documents into evidence, authenticating them. She is permitted pursuant to 9803, I believe it's subsection 6, which is the hearsay exception for business records, to testify as to the contents of those records. Ms. Carpenter wasn't providing any sort of opinions. She wasn't giving her opinion on the documents that were contained in the record. What she was doing was testifying with respect to the documents that were authenticated and properly admitted into evidence for the purposes of the summary judgment hearing. That's a lot different than the cases Savoy, Mesa, the other cases that appellant cited in this case that are addressing affidavits where either the corporate representative did not have any knowledge or they were attempting to present testimony and opinions at trial on documents that were never admitted into evidence and weren't authenticated and part of the record.
So at what point did the hearsay objection get raised in these proceedings?
Thank you. Yes, that's a great point, Judge Morris. That was not raised until the reply brief in this case.
So what does that mean?
It means that it was waived on appeal, Your Honor. It's page 29 and 30, I will say, of their initial brief, because we went back and looked at this issue specifically. It raises the insufficiency of the corporate representative's affidavit, but it doesn't raise it in the context of hearsay, which was presented for the first time to this court in the reply brief. So I do agree with Your Honor that that was a point that was waived through the.
I haven't said anything.
I appreciate the question. It's my position that it was waived, and I appreciate that. And I do believe either way that it was properly considered and properly by the trial court at the trial level for the reasons that I provided, Your Honor. To address the court's questions with respect to Hopgood's deposition, or I'm sorry, Hopgood's affidavit. This affidavit was inadmissible. There was no factual foundation for it whatsoever. During the trial hearing, plaintiff's counsel specifically indicated that it was the same affidavit that had been presented in a different case. And both of those affidavits appear in the record. The one from the second case appears at 1235 in the record. And if you look at those, they're identical. The only thing that's different is the recitation to the date of loss and the cause, the specific cause being the April 20th storm. However, if you look at the report, it is inconsistent with the report. It's not necessarily inconsistent. It's absolutely inconsistent. We have an affidavit where the affiant is testifying that this was the April 20th, 2020 storm. However, there were 6 storms in between when the alleged date of loss occurred and when the inspection occurred. That was completely ignored.
At the end of the day, the appellant, plaintiff below, had an affidavit that says our damage was caused by a storm, right? I mean, summarizing, that's what they say. You had an affidavit that said, no, it's wear and tear. And the court said, gee, these are a tie. I can't reconcile them. And this is at the summary judgment stage. Is that appropriate?
If Your Honor, the court actually considered it to be a tie, then it may be inappropriate. However, here we have an instance where the trial court specifically determined that Hopgood's affidavit didn't present sufficient evidence that would establish that there was any storm-related covered damage that occurred created an opening and allowed the rain to enter. So Your Honor, no, it isn't a tie, because the mere fact that there was a storm that may have created some
Is it
damage.
appropriate at the summary judgment stage for a trial court judge to weigh the credibility of two opposing affidavits and determine that they're a tie? Is that what goes on in summary judgment?
No, Judge Morris, that it would not be appropriate to actually weigh the credibility
what
of the two
happened here?
affidavits. No, Your Honor, it's not our opinion that
Well,
that's what happened here.
According to the transcript, Judge Kelly below said, I've looked at these affidavits and they're a tie.
That was a comment that was made during the
What are
hearing.
we
Your Honor.
supposed to make of that? It sounds like that's a weighing of the credibility of those affidavits.
Your Honor, that's not the foundation for the court's ruling. I do agree that that is a statement that is contained within the record, but if you look at the actual record evidence that exists, there's no reliable factual foundation for Mr. Hopgood's affidavit in this case. And if you look at the totality of the affidavit and the report that he's allegedly relying on, because he has relied on it, because he did not go out to the property, there's nothing to support any
So are you asking
statement.
us to weigh the evidence here?
No, Your Honor, I'm not asking you to weigh any evidence, because there is no admissible evidence that's contained within the affidavit and the report in this
There
case.
were photographs attached to the report, right?
There are
So
photographs.
Mr. Hopgood, in his independent professional judgment, could have looked at those photos and reached a different conclusion than AQI did, right?
Your Honor, not based on the record that we have here, because he wasn't out to the property to observe any of
He
this
looked,
damage.
he looked at the photos, though. And he looked at the photos, he reviewed the weather reports, he relied on the factors that in his affidavit, he said are factors that experts typically rely on. And was he required to simply rubber stamp AQI's report, or could he exercise his independent judgment and write up his affidavit accordingly?
It would still need to be reliable, Your Honor, and based upon his statement that it was this specific storm, when you have numerous storms that occurred and absolutely nothing in the report that would indicate that it was the April 20th, 2020 storm that created any sort of damage that allowed rainwater to enter. It's purely speculative at best.
Wasn't that consistent with what the homeowner had told him in terms of the timing of when the leaking started?
Well, Your Honor, if you look at record page 320, Ms. Lassiter, she did not know when it started. She actually saw it for the first time in June and related it back to the April 20th storm. So she didn't even know when it occurred.
Well, she knew when the leaking started, right? Even if she didn't specifically know.
But her testimony was that she saw it, the leaking start in June 3rd or June 4th.
Right.
And she correlated it back to the April storm, but she had no basis for that correlation.
Except that was the storm with the big hailstones and that kind of thing, right?
And Your Honor, Mr. Hopgood's affidavit in his report, if you look at that report, it specifically says at record 523, conditions were adequate to cause damage, but quote, did not have hail size large enough to cause damage.
Is that Hopgood's?
That was Hopgood's.
determination? Okay, not AQI's?
It was AQI's, but he was relying on it. He relied upon the statements and the observations and the inspection of AQI, because Mr. Hopgood did not go out to the property. He was only reviewing their results.
But he independently checked the weather reports, right? Didn't he say that in his affidavit?
Presumptively, yes. Your Honors, it's our position that there must be credible, admissible evidence that's reliable in order to establish and to meet plaintiff's burden to establish that there was an exception to this exclusion. There's no question that it was rain in this case that caused the interior damage. The question is with respect to whether there was a storm-related opening in the roof that allowed the rainwater to enter in. And there was no testimony in this case that was reliable or admissible or competent. And we're requesting that the court affirm on all grounds. Thank you.
Yes, sir, you have 5 minutes.
I may not, try not to use them all, Your Honor. I just want to touch upon a couple of things. One, the authentication versus hearsay. We have no objection to the authentication of the photographs. What we object to is the hearsay conduit for the field adjuster's opinion. And Mr. Hart did raise that on page 30 of the hearing transcript. Finally, if the court was even to consider the Carpenter affidavit, it has to say why she's competent to testify as to her hearsay statements. So that was raised in the court below. The other issue regarding the storms, that's fodder for cross-examination. And then how Ms. Lassiter could correlate the fact that she heard the hail or something hitting her roof, because it doesn't have to be hail to create the opening, but how she heard that and then saw leaking in June, she correlated that. A reasonable jury could do the same. Therefore, we ask that this court reverse. Thank you for your time.
Thank you both. You did a nice job here today, and I appreciate your help in illuminating these issues so we can try to figure out what to do in this case. Have a good day.
Thank you.
Our next case is Bam versus Villa at Cypress Run West.